Broadcast is now starting. All attendees are in listen-only mode.
All right, welcome everyone to today's compliance webinar. These are ALTA's presentations we offer each quarter on issues important to title professionals. I am Jeremy Yowie, ALTA's Vice President of Communications, and today we've got a great webinar lined up as we offer the second in a four-part series on insuring Native American land. Before turning the presentation over to our moderator, Orlando Lucero of the FNF family of companies, I do need to touch on a few housekeeping items. All participants, attendees are, their mics are muted for today's presentation. If your audio is choppy, you may have a weak internet connection or Wi-Fi maybe, so you may need to select the telephone option. A copy of today's presentation can be downloaded from the handout section of the GoToWebinar window on your computer screen. You'll also find some additional material that will be referenced during the presentation, as well as a copy of the presentation from part one of this series. We will hold some time at the end for Q&A, so please feel free to send us questions. And today's presentation is being recorded. We'll get a link to the recording out to everyone by tomorrow. And before we start, I do need to extend a thank you to Old Republic Title Insurance Company for sponsoring our compliance webinars this year. And with that, Orlando, I will turn the presentation over to you.
Great, thank you very much. Again, my name is Orlando Lucero, and I'm the New Mexico State Underwriting Counsel for the Fidelity National family of companies in Albuquerque, New Mexico. And on behalf of ALTA's Native American Lands Committee, it's my pleasure to welcome you to the second in our four-part series, Insuring Native American Land, Special Issues and Considerations. I'm the moderator for this segment, and I hope that you already have taken the opportunity to view our first program, which, as noted, is available here during this program and is also available on the alta.org/webinars page. Part one of our series focused on the different types of native lands ownership, the Federal Non-Intercourse Act, and Section 17 corporations. Today's program will build particularly on what we have learned already in part one, and will explore the statutory and regulatory authority and processes for entering into leases of restricted Native American lands. Again, please feel free to download the materials from the taskbar. Now, I would like to introduce our three speakers. Each is a member of the ALTA Native American Lands Committee and is very knowledgeable about and experienced with native lands transactions. Our first speaker is Sam Scheel, who is Vice President, National Underwriting Counsel with Old Republic National Title Insurance in Chicago, Illinois. Our second speaker is Cindy Guanell, who is Regional Underwriting Director for the Pacific Northwest region of First American Title Insurance Company, and she hails from Meridian, Idaho. Our final speaker today is Rolf Lindberg, who is Senior Underwriting Counsel with Stewart Title Guarantee Company in Minneapolis, Minnesota. So Sam, take it away.
Thank you, Orlando. Today I will be discussing leasing of tribal lands from its beginnings through the passage of the Long-Term Leasing Act of 1955, which is more commonly known as Section 415. Whoops, can I go back one? There, oh. Sorry about that. This is a statement from the Bureau of Indian Affairs, Branch of Real Estate Services, Leasing Manual published in 1984. Some form of land leasing has been practiced virtually from the beginnings of civilization. Although leasing Indian land involved several unique features, the basic essentials have come down from the legal systems developed by the European colonizers of the North American continent, most notably the English. The authorities for Indian leases have evolved with the development of federal Indian policy and the pressures generated by Indian and non-Indian interests. Leasing has become a major activity in the performance of federal trust responsibilities by the Bureau of Indian Affairs. The Secretary of Interior's trust principles are documented in the U.S. Department of Interior's Department Manual. While there is no statutory requirement that tribal lands held in trust by the United States government be leased, the Secretary of the Interior has a fiduciary obligation to protect and preserve Indian trust assets from loss, damage, unlawful alienation, waste, and depletion, and to make decisions concerning trust lands that are in the best interests of the Native American landowner. And one of the most effective ways to meet these fiduciary obligations for trust lands is to put the land under lease. The basis of the tribal regulatory relationship between tribes and the federal government was established in the Commerce Clause of the U.S. Constitution in Article 1, Section 8, Clause 3. The Commerce Clause gives power to Congress to regulate commerce with foreign nations and among the several states and with the Indians. This relationship as it pertains to land use and ownership was clarified in the 1820s and 30s through a series of Supreme Court decisions known as the Marshall Trilogy, where former Supreme Court Justice John Marshall established several important principles of tribal law. In Johnson versus McIntosh in 1823, holding private citizens could not purchase lands from Native Americans. In Cherokee Nation versus Georgia in 1831, holding the Cherokee Nation dependent with the relationship to the United States like that of a ward to its guardian. In Worcester versus Georgia in 1832, which laid out the relationship between tribes and state and federal governments, stating that the federal government was the sole authority to deal with Indian nations. Native American land ownership involves a complex patchwork of titles, restrictions, obligations, statutes, and regulations. One of these concepts is the federal Native American trust responsibility, whereby the government charged itself with moral obligations of the highest responsibility and trust toward Native American tribes. In this capacity, the U.S. government maintains a fiduciary responsibility to protect Native American assets and resources and serves as trustee for Native American lands. Another was the principle that tribes are sovereign, which is inherent to them as the original governing bodies of what is now the United States. And that sovereignty can only be diminished by Congress. In order to better understand tribal land leasing, you have to determine the limits of tribal authority, which can be difficult to ascertain. Not all tribal land is located within the geographical boundaries of a reservation, and some property within a reservation may individually be owned in fee. The term Indian country has evolved over time and has been described as country within which Indian laws and customs and federal laws relating to Indians are generally applicable. The current definition of Indian country is found at 18 U.S.C. section 1151, which, although is part of the criminal code, has applications in civil affairs as well. Except as otherwise provided in sections 1154 and 1156 of this title, the term Indian country as used in this chapter means A, all land within the limits of any Indian reservation under the jurisdiction of the United States government, notwithstanding the issuance of any patent and including rights of way running through the reservation. B, all dependent Indian communities within the borders of the United States, whether within the original or subsequently acquired territory thereof, and whether within or without the limits of a state. And C, all Indian allotments, the Indian titles to which have not been extinguished, including rights of way running through the same. Consistent with the statutory definition of Indian country, as well as federal case law interpreting the statutory language, tribal lands held by the federal government in trust for tribes that exist outside of a reservation are also considered part of Indian country. And conversely, it should also be noted that Indian country includes land owned by non-Indians within the exterior boundaries of a reservation. During the 1850s, the modern meaning of the tribal reservation emerged, which refers to land set aside under federal protection for the residence or use of tribal Indians, regardless of origin. During that time, the federal government began reserving public lands from entry for tribal use. This use of the term reservation from public land law soon merged with the treaty use of the word to form a single definition describing federally protected Indian tribal lands without depending on any particular source. In Indian country, most economic and community development activity depends on the status of the land. Both tribes and individual Native Americans own lands in three different categories: trust, restricted fee, and fee simple. Other methods of ownership include allotments and fractionation or divided ownership. Most Native American lands are trust land, for which there is approximately 56.2 million acres of land held in trust by the United States for the various Native American tribes and individuals. Indian-owned land within a reservation can include land owned by the tribe, land owned by the tribe's business entities, land owned by individual tribal members, and land owned by non-member Indians, any of which may be subject to federal restrictions on alienation, held in trust by the U.S. for the Indian owner, or owned in fee simple. Only land held in fee simple by individual Native Americans can be transferred, including leased, without federal authority or written approval by the Secretary of the Interior, although the validity of this principle has been questioned. The Bureau of Indian Affairs is the agency that is responsible for the administration and management of lands held in trust for Native Americans. The BIA is responsible for restrictions and oversight regarding alienation, leasing, inheritance, and encumbrance of tribal land. To that end, the BIA has promulgated numerous detailed regulations that implement statutory obligations and discretionary duties related to trust assets. These include regulations to acquire land in trust status for the benefit of individual Native Americans and tribes, to remove alienation of Native American allotments, to approve and cancel leases of tribal and individual trust lands. The BIA is responsible for trust fund management, and in the fiscal year 2017, the Department of the Interior invested more than $5 billion in trust fund assets on behalf of tribal and individual Indian beneficiaries, received $1.4 billion into tribal and individual Indian beneficiary accounts, and dispersed $1.36 billion from those accounts. Trust fund accounts are made up of funds received through the sale or lease of trust lands. Congressional authorization for leasing of both tribal and allotted land to non-Native Americans began during the allotment and assimilation period of the late 19th and early 20th centuries, when federal tribal policy favored putting tribal lands to productive use. In the early days of the Republic, Congress passed a series of statutes known as the Non-Intercourse Act, which set the boundaries of reservations and also regulated commerce between settlers and tribes. The Non-Intercourse Act prohibited leasing or other encumbrance of Native American lands by non-Native Americans, except as expressly permitted by Congress. General statutory authority for leasing tribal lands did not exist until after the passage of the Dawes Act of 1887. After passage of the Dawes Act, there were a series of principal acts of Congress governing surface leasing. And with the passage of the Indian Reorganization Act of 1934, the allotment era came to an end. The IRA ushered in restrictions and oversight from the BIA regarding alienation, leasing, inheritance, and encumbrance. To change or update prior land use arrangements, as well as enacting new agreements, required BIA approval at several different administrative levels. Therefore, altering or instituting any land use agreements would take several months and could be costly. Federal oversight of leasing is provided at agency or field level by a designated superintendent, and the superintendent's authority comes from the Secretary of the Interior through a series of redelegation orders. Early statutory authority on leasing tribal land was restrictive. There was a 5-year maximum length of lease, and a new lease or renewal required BIA approval at several different levels. This resulted in increased transaction costs associated with leasing, with the short lease lengths combined with high transaction costs for lease renewals. It reduced incentives for outside investors to develop long-term projects. Although none of these statutes has been repealed, they are rarely used today, with the exception of the Indian Reorganization Act Corporate Charter Leasing Authority under 25 U.S.C. Section 5124. This provides tribes the ability to petition the Secretary of the Interior for a charter of incorporation. And this charter may convey to the incorporated tribe the power to purchase, take by gift or bequest or otherwise, own, hold, manage, operate, and dispose of property of every description, real and personal. However, no authority shall be granted to sell, mortgage, or lease for a period exceeding 25 years any trust or restricted lands included in the limits of the reservation. The only way a charter that is issued to a tribe can be revoked or surrendered is by an act of Congress. Most modern leases of non-agricultural lands are made under the Indian Long-Term Leasing Act of 1955, better known as Section 415. The complete list of statutory authority for leasing of Native American lands is found at 25 U.S.C. Chapter 12, lease, sale, or surrender of allotted or unallotted lands. Most non-agricultural surface leasing today of both tribal and allotted lands is conducted under Section 415. Due to the inalienability of Native American lands, ground leases have been critical in allowing for the development of Native American lands. Any restricted Indian lands, whether tribally or individually owned, may be leased by the Indian owners with the approval of the Secretary of the Interior for public, religious, educational, recreational, residential, or business purposes, including the development or utilization of natural resources in connection with operations under such leases, for grazing purposes and for those farming purposes which require the making of a substantial investment in the improvement of the land for the production of specialized crops as determined by said Secretary. Subject to the exceptions noted in 415, leases so granted shall be for a primary term not to exceed 25 years and a single renewal period of up to 25 years, except leases of land located in specifically delineated reservations. So what did Section 415 accomplish? It extended the possible term of leases on trust lands from 5 years to 25 years, with one additional renewal for 25 years subject to BIA approval. It established a process to approve leases, set lease terms and forms, and control lease cancellation through the authority of the BIA. Various amendments confer 99-year leasing authority on more than 50 named tribes, and this all helped to spur economic development. Under Section 415, different tribes may have different terms approved for their leases. For example, any lease involving the Tulalip tribes do not require approval of the Secretary of the Interior if the term of the lease does not exceed 15 years with no option to renew, if the term of the lease does not exceed 30 years with no option to renew and the lease is executed pursuant to tribal regulations that are previously approved by the Secretary of the Interior, or if the term does not exceed 75 years including options to renew, and the lease is executed under tribal regulations approved by the Secretary under this clause. And this was codified at Section 415B. In 2000, Public Law 106-568 was passed, and the purpose of this law was to authorize the Navajo Nation, pursuant to tribal regulations which must be approved by the Secretary, to lease Navajo trust lands without the approval of the Secretary of the Interior for the individual leases, except leases for exploration, development, or extraction of any mineral resources. And this was codified at Section 415E. So Secretary approval is not required for Navajo Nation leases if the lease is executed under tribal regulations, the term of the lease is 25 years, except that any such lease may include an option to renew up to 2 additional terms, each of which may not exceed 25 years. And under Section 415A, it's interesting to note the Secretary approved leases are for 99 years. And an environmental review is conducted. In 2005, the Navajo Nation submitted the Navajo Nation Business Leasing Regulations to the Secretary of Interior for approval. The BIA then attempted to reinsert itself into the process by rebuttal to the Navajo draft regulations. There were 2 main points of contention. The first was that the tribal regulations must be consistent with the Code of Federal Regulations. The Navajo Nation took the position that this process was consistent, and any inclusion of the BIA contradicted the intent of the statute. The other point of contention was how the BIA was to maintain its trust responsibility without some kind of oversight or monitoring, and the Navajo Nation took the position that it was the intent of Congress to give full authority to tribes with no approval or monitoring by the BIA. In 2006, after the Navajo Nation submitted a second draft, the DOI approved the regulations and concurred that the statute was to give full autonomy to the Navajo tribe over leasing. And in 2012, the HEARTH Act was signed that allows the tribe to enter into a similar process allowed to the Navajo Nation on tribal land under their own regulations as long as the BIA has approved their leasing regulations. And Rolf and Cindy will discuss the HEARTH Act and the regulations under 162 in greater depth during their portion of today's presentation. And now I turn the presentation over to Cindy to talk about the regulations under 162.
Thank you, Sam, and thank you for that excellent background information. As Sam mentioned, hang on, oh, there it goes. As Sam mentioned, 25 U.S.C. 415, the Long-Term Leasing Act, is the act that allows leases for Indian land subject to secretarial approval, that being the Secretary of the Interior. 25 CFR, which stands for Code of Federal Regulations, at Part 162 is the rule establishing the procedures for obtaining that secretarial approval of leases, as well as the administration and enforcement of surface leases. Today, I'm going to be providing an overview of this rule. Effective January 4th, 2013, Part 162 was substantially revised to make the procedures for obtaining BIA approval of lease documents as transparent as possible. This rule applies to surface leases only, not mineral, for residential, business, and wind and solar leases, and specifically excludes agricultural leases. It's important to note that wind and solar leases have their own rules under this part and do not fall within the business leases segment. Part 162 applies to surface estate owned by a federally recognized Indian tribe or individual Native American in trust or restricted fee. It also applies to the surface estate held by the United States in trust for an Indian corporation chartered under Section 17 of the IRA from 1934, which we refer to as Section 17 corporations that Sam mentioned earlier. And this also applies to land reserved for BIA administrative purposes. As Orlando just mentioned, we covered vesting in Section 17 corporations in Part 1 of this webinar series, which is recorded and available to you on the ALT website. If you haven't listened to it yet, I encourage you that you do so. This part does not apply to land held in unrestricted fee simple interest. If a tribe owns the property in unrestricted fee, it would not have authority to lease their land under any of these regulations. And 25 U.S.C. Part 177, the Indian Non-Intercourse Act, would arguably apply. So that is just one example of why it's important to understand exactly how the tribe holds title to the property. The general provisions of Part 162 set forth procedures and rules governing the access to the lease premises, what approvals are required, consent requirements, the lease terms, recording of lease documents, jurisdiction, what laws apply to the leases, and sovereign immunity. We'll talk about each of these provisions as we go through this presentation, but first I want to talk about what approvals are necessary. As a side note, leases in effect prior to the date of these revised regulations in 2013 should have complied with regulations that were in effect at the time that the ground lease or initial sublease were approved by the BIA. And since the regulations were revised in 2013, then any ground lease and sublease existing prior to 2013 are now governed by the revised regulations, except to the extent that the lease, which presumably was approved and complied with previous regulations, is in conflict with these revised regulations. Federal statutes require the Secretary approval to approve all, or the Secretary to approve all leases of Indian land except a lease of tribal land by a Section 17 corporation by a third party for a period not to exceed 25 years, and a lease of Indian land under a special act of Congress authorizing leasing without BIA approval, such as Sam just spoke about in 415B and E, and Roth will talk about the HEARTH Act. One of the key terms of Part 162 is the definition of lease documents, which is a lease, amendment, assignment, sublease, or subleasehold mortgage, or leasehold mortgage. So essentially, the lease and all associated documents require approval. However, there are a few exceptions to the rule regarding the amendments, assignments, and subleases, but they're subject to certain conditions. BIA approval of a lease amendment is required. However, if the BIA does not send a determination within 30 days from receipt of the required documents, the amendment is deemed approved to the extent consistent with federal law. It's important to note that unless the lease provides otherwise, any provisions of that amendment that are inconsistent with federal law will be severed and unenforceable. If the amendment was deemed approved, the amendment becomes effective 45 days from the date the parties mailed or delivered the documents to the BIA for review. A sublease requires BIA approval unless the lease provides for subleasing without meeting consent requirements or obtaining BIA approval, and the sublease does not relieve the lessee or the sublessor of any liability. And in business leases, it must be part of a commercial development or residential development, and the parties must provide the BIA with a copy of the sublease within 30 days of when it's executed. Approval of the lease assignment is required unless the lease is for housing or public purposes, or the assignee is a leasehold mortgagee or its designee acquiring the lease either through foreclosure or by conveyance. And the assignee agrees in writing to assume all the obligations and conditions of the lease, and the assignee agrees in writing that any transfer of the lease will be in accordance with applicable law. If it's a business lease, it cannot be assigned to more than 3 distinct legal entities specified in the lease, or must be to the lessee's wholly owned subsidiaries. The lessee must notify the BIA of any assignment 30 days after it's executed. I would use caution when relying on deemed approval. If the BIA didn't receive the documents, or if all the conditions were not met, which may be very difficult for us to determine, the document can be declared invalid. So I suggest if you're in a situation where a client is asking you to accept a lease document that does not contain BIA approval, that you immediately contact your underwriter for instruction on how to proceed. And I think it's important to keep in mind also that the lease may also speak to this as well. So even though 162 may allow with certain conditions for the assignment or the sublease or amendment to not need to be approved, the lease may require approval for those things. So again, another reason why we want to be sure to look at the underlying lease agreement. Leasehold mortgages, on the other hand, always require BIA approval. The BIA has 20 days from receipt of the executed leasehold mortgage, proof of the required consents, and required documentation to approve or disapprove the leasehold mortgage. If the BIA does not meet the deadline in this section, the lessee can take appropriate action, but it is not deemed to be approved. On the other hand, unless the lease or sublease provides otherwise, or by request of the parties, BIA approval is not required for a subleasehold mortgage. If the lease or sublease requires approval of the subleasehold mortgage, or parties request BIA approval, the BIA will use the same procedures governing the review of the leasehold mortgage. Consent requirements. Part 162 requires that the tribal landowner or the individual Indian landowners must consent to the lease. For fractionated tracts, except in Alaska, a percentage of the owners must consent. Leases in Alaska require consent of all the Indian landowners in the tract. Tribal land that is already subject to a tribal land assignment may only be leased with consent of the tribe, even if individually owned. While it is true that landowners actually grant the lease, the BIA commented when they revised the rule that they adopted the language of the Indian Land Consolidation Act of 2000 in referring to the word consent, to avoid potential confusion where there are several owners of a fractional interest and one grants the lease but the others do not. Jurisdiction. What laws apply to leases? This is an important question if you're insuring a leasehold interest on Indian land. Native American tribes are self-governing political entities that can establish their own distinct body of law and tribal court system. If a tribe has established a body of law, those laws may not recognize the legal principles that serve as a foundation for our day-to-day underwriting. If state law doesn't apply, then we need to understand and become comfortable with tribal law applicable to real property and the coverages provided under the title insurance policy and the title endorsements. Part 162 specifically sets forth that leases approved under this part are subject to applicable federal laws and subject to tribal law. In fact, these particular regulations may be superseded or modified by tribal laws. Of course, that applies only to tribal land. With limited exceptions, leases entered into Part 162 are not subject to state law unless the Indian tribe with jurisdiction has made state law expressly applicable, Congress has made state law expressly applicable to specific areas, or a federal court has expressly applied state law to a specific area or circumstance in Indian country in the absence of federal or tribal law. Under Part 162, the parties to a lease may subject that lease to state or local law in absence of federal or tribal law if the lease includes a provision to this effect, and the Indian landowners expressly agree to the application of state or local law. We want the tribe to agree that the lease shall be governed by the laws of the state in the United States. If there is a dispute as to the validity of the lease, and we ensure the validity of that lease, we want to be able to defend our insured in state court pursuant to state law. However, this agreement to apply state law does not waive the tribe's sovereign immunity, which is a distinctly different issue. Federal law recognizes each tribe as a sovereign government, comparable to the government of a foreign country. As such, it cannot be sued unless authorized by federal law, or the tribe has consented to suit in accordance with its tribal law. This sovereign immunity may extend to an entity or arm of the tribe, such as a corporation, limit to liability company, partnership, trust, or similar entity formed under federal, state, or tribal law, in which the tribe has an ownership interest or control. Sovereign immunity extends to tribal officials and applies to both on and off reservation activities. When we are ensuring the validity and enforceability of the lease, the tribe should waive its respective sovereign immunity from suit and consent to jurisdiction and venue in state court or in federal court within the United States of America, having appropriate jurisdiction. Your underwriter may require that the title insurer is an intended beneficiary of the waivers, agreements, and consents, so they know they can rely on those waivers and consents. Contracting alone does not waive sovereign immunity. Pursuant to Part 162, in order to waive its sovereign immunity, the tribe must expressly state its intention to waive sovereign immunity in the lease document. Access to the lease premises is also governed by these regulations. A lease may address access to the lease premises by roads or other infrastructure, as long as the access complies with applicable statutory and regulatory requirements, including 25 CFR Part 169. And note that it's the obligation of the parties to the lease, not the BIA, to ensure access to the lease premises. So 25 CFR Part 169 provides the procedures for granting rights-of-way over Indian land under the statutory authority of 25 USC 323, which empowers the Secretary of the Interior to grant rights-of-way across Indian lands held in trust or restricted status. Access to the lease premises should also be verified. A valid easement or right-of-way is required to cross Native American land, just like it would be required for someone to trespass on your land or my land. Even a road or highway designated as county or state that crosses Native American land would need a valid easement agreement. And many of these access easements and rights-of-way are for a term of years, so it's advisable to check for the expiration of these grants. However, roads or other infrastructure within the lease premises do not require compliance with 25 CFR Part 169 during the term of the lease unless otherwise stated in the lease. Another reason to review the lease agreement. And we'll be having a more comprehensive discussion about access in Part 3 of this webinar series, which is scheduled for the second quarter of 2021. Let's talk a little bit more about the lease term. As Sam mentioned earlier, the maximum terms of a lease cannot exceed that allowed by federal law. For example, leases under 25 USC 4211, which is also governed under Part 162 and is specific to leases for housing development and residential purposes, allow a 50-year term. But leases under 25 USC 415A must consist of an initial term of 25 years with one renewal of 25 years for a total of 50, unless otherwise stated in 415A, which Sam talked about, the 50 tribes that have codified under 415A to be allowed a 99-year lease. So the first step I take to ensuring a leasehold interest on Native American land is to determine under what regulation or authority the tribe or individual Native American is acting. As with any leasehold transaction, it's important to review a copy of the underlying ground lease, even if you are insuring a sublease. If the lease fails, the sublease also fails. The lease document should tell you what regulations the tribe is acting under, so you should be able to verify that the term of the lease is consistent with the regulations. A lease exceeding the term statutorily allowed could void the lease agreement, and the lease documents requiring secretary approval are invalid if that approval is not obtained. To be effective, the lease documents must be recorded in the Land Title Records Office, which we refer to as the LTRO. The BIA Land Title Records Office is where all documents affecting title to lands held in trust or restricted fee are entered. The LTRO records are not open to searches by the public. The only way to obtain the information is to request a certified title status report. Some LTROs will accept a request for a certified TSR from a title company, but others require the property owners to make the request. And maybe even they require the tribe to make the request, even if the property owner is an individual. Obtaining a certified TSR doesn't happen quickly. In some cases, it can take weeks or even months to obtain a copy, and it may take even longer to get certified copies of documents that are listed on a TSR. Remember, these lease documents and these leasing regulations, only apply to land held in trust or restricted status. So all records will be located in the Land Title Records Office. And this rule requires that all lease documents, except residential subleases, be recorded in the LTRO in order to be effective. It's also advisable to record the documents in the county where the land is located. A residential sublease is the only lease document that isn't required by this rule to be recorded in the LTRO. So when I think about this, I think about if we are relying on a certified TSR in a residential transaction, and if residential subleases are not required to be recorded, then certainly there could be one that exists that is undocumented. The BIA should record the lease or other documents in the LTRO immediately following their approval. This is something that we may want to verify with a new TSR. If secretary approval of an assignment or sublease is not required, the parties must still record the assignment or sublease in the LTRO with jurisdiction over the leased land. Part 3 of this webinar series will also talk more about the Land Title Records Office and recording documents. So again, stay tuned for Part 3 of this series in the second quarter of 2021. Earlier, we talked about two types of leases that don't require BIA approval. Those being leases of tribal land by a Section 17 corporation to a third party not exceeding 25 years, and leases of tribal land under a special act of Congress authorizing leases without individual lease approval. However, it's important to know that these lease documents must still be recorded in the LTRO, even though approval of the lease wasn't necessary. So let's review a few of the important items to consider when ensuring a leasehold transaction on Native American land. Who owns the underlying fee interest in the land? If the land is held in the tribe in unrestricted fee simple, then these regulations don't apply, and the Non-Intercourse Act may apply. We should understand exactly how title is vested. Under what regulation or authority was the lease entered into? Again, you should be able to make this determination by reviewing the lease agreement. What is the term of the lease, and does it comply with the governing regulations and authority? Is current approval of the lease by the Secretary required? Has a current certified title status report been ordered from the Land Title Records Office? Has access to the lease portion of the land been established? And is there legal access from the leased land to a county road outside the reservation? Last but not least, did the tribe or tribal entity expressly state its intention to waive its respective sovereign immunity from suit in the lease document? And did they consent to jurisdiction, venue, and choice of law in the court of the state in which the land is located? So these are just a few things to consider that I think you could probably use this as a sort of checklist. With that, I'm going to hand this over to Rolf to complete the presentation.
All right, thank you very much, Cindy. And my charge today is to talk about the HEARTH Act, which is actually somewhat of a subset of all the leasing regulations and the Long-Term Leasing Act that Sam was talking about earlier. The HEARTH Act was passed in 2012, and nobody loves an acronym better than Congress, so here's what they came up with: helping expedite and advance responsible tribal home ownership. The home ownership part, to me, is kind of a misnomer. It certainly deals with residential leases for long term, but it also talks about business leases, public purpose leases, energy leases, things like that. So it's basically a leasing subset statute. And they put it at the very end of Section 415H, and it's a special leasing program in the sense that Sam was mentioning the Tulalip tribe and the Navajo tribe and those with the 99-year leases, et cetera, that are specifically described. There's no tribe specifically described in 415H. It's everybody. So anybody can apply and become subject to the HEARTH Act. And the best part to me from a distance looking at this is once you have your tribal leasing ordinance or regulation approved by the BIA no longer needs to approve every lease. So you're covered with your ordinance, and at that point, the tribe is set free to basically, deal with their own land. Who knows their own land better than they do? More on self-determination, sovereignty of the tribe, and from our standpoint, which is usually more the business standpoint, it's more efficient and eliminates the extra bureaucratic step of having the BIA sign off on each lease. So how do we get there? Where is it allowed? You start with, it's only allowed on trust land or restricted fee land that's owned by the tribe itself. What is not allowed is to have leases that are on land owned in allotment by an individual member or owned in fee simple, or if you have cases where you have fractionated interests, like multiple parties and maybe the tribe is one of them, that's not allowed either. So it's got to be all tribal trust or restricted fee land. And the other thing that's not allowed under the HEARTH Act is mineral exploration kind of leases. So we're talking about surface leasing only. I'm sure there's different programs that talk about the mineral part, not this one. So the types of leases that are covered, you could do business and agricultural, residential, energy leases for wind and solar, or there's a kind of a catch-all public and religious, educational, and recreational purpose leases that are allowed as well. So you can see this goes a lot beyond the home ownership acronym that they came up with at the very beginning. So I'm going to go quickly through the terms of the leases that are allowed under HEARTH, but the point here is that these are maximums that are allowed, so kind of the ending of the right of way for where you get to. A tribe is certainly free to do a lesser term or slice this in a different way, but in a lesser way than is expressed here. So for business and ag leases, you can have a 25-year term with up to 2 additional renewals. A residential lease, you have up to 75 years on a residential lease. For wind and solar resource leases, this is a little bit, it's a little bit different because you don't see those leases described specifically in 415H, but when you look at the CFR Part 162, which Cindy was just talking about, and you also look at the Indian Affairs Manual, it's clear that the BIA treats these wind and solar resource leases as part of HEARTH as well. So for a wheel, which is a wind energy evaluation lease, you can have a 3-year term of the lease with up to a 3-year option to renew. It makes sense that that's a shorter term because they're just looking to see whether a wind project, a bigger wind project would be viable. And then for the wind and solar resource lease, you can have up to a 25-year term with one 25-year option to renew. And then similar to what they do with residential leases, these public purpose kinds of leases can also be for up to 75 years under this program. So the process is very stepwise oriented with the BIA in their regs and also under the statute as well. This part is from 415H. The first thing, the tribe has to have an ordinance or a regulation that they submit to the BIA for review. And the two big things under 415H are that it has to be consistent with, and that's the exact term they use. It's got to be consistent with the regulations that are under 25 CFR Part 162. And it also must provide for some kind of environmental review process so that they can identify significant environmental effects of whatever project they're doing. The idea of consistent with, Congress certainly considered a more strict standard to apply in 415H, and they were thinking about maybe doing a meets and exceeds standard at first, but they felt that in terms of deference to the tribe and allowing them to make their own decisions about what they can do with their own land, the consistent with standard is what was adopted. So it doesn't mean they have to follow 162 exactly, they just have to be consistent with it. So as a part of that, you need to define the key terms, which a lot of those are in 162 already, but also in the lease itself, they want to define key terms, and probably not differently than they are defined in Part 162. And then they need to establish a process for review and approval of the lease documents. That's not the BIA, that's at the tribal level, they establish a process for that. And then, as mentioned under 415H, they need to include an environmental review process of some kind that provides the public an opportunity for comment and tribal response. That certainly is going to vary depending on what project you have, what kind of lease you have, and some of those determinations are left within the hands of the tribe to figure out what is a significant environmental effect and what isn't. When you go back to key terms, that's one of the things they want the tribe to define, is what is that? And then there's obviously going to be some discretion and some opportunity for getting the public to comment. Any good lease has to have the lease elements, so we expect to see what is the property. You got to describe it so they can record these things correctly. How long does it last? Do you build improvements? All those kinds of things. And then the rental requirements. Everybody's got to pay rent, so they have to have a figure for determining that. Whether there's taxation for improvements that are added to the property, things like that. And then, of course, not all leases end happily. So if there are violations, there must be some kind of procedure within the lease for enforcement of the lease, for defaults or cancellation by the tribe. So what else can be included? The tribal ordinance can allow for mortgages to be granted on the leasehold interest. That is not to say that you can't allow to have a mortgage on the tribal trust land itself, but on the leasehold interest they can. And I've included in the materials today, the Pueblo of East Letta had a leasing ordinance approved by the BIA last year. And in that, is a good example. They allow for mortgages to be granted on the leasehold under certain circumstances and in a certain way. Also, the tribal regulation can, as Cindy was pointing out, it can address access, but doesn't itself allow easements and rights of way because those are addressed in another area. And finally, on this part, substantive changes to the ordinance or regulations will, if it's substantive, it will trigger a further BIA review and approval of the ordinance, but not in the case of a minor technical amendment. So for those who are lawyers out there, If you want to tell me what the difference is between a minor technical amendment and a substantive change where it's not defined, we can have that discussion offline. As the approval process goes through, and I've included in your materials part of the Indian Affairs Manual that actually addresses this specific piece. It's very stepwise oriented. They're very coordinated about who reviews it and when. Solicitor's office, regional realty folks, input from the tribe, all the way through until you get to your 120 days. So they're very organized about how they do it. But you have, and the way they frame this is the Secretary of Interior, BIA, shall approve or disapprove within 120 days. So that the clock is ticking once they get all their submissions in place and everything's ready. So there is an option to extend if they're not meeting the 120-day deadline, if the tribe agrees to. But if they're going to disapprove it, they need to do it on a method where they submit the actual reasons and written documents for the disapproval. So once it's approved, it's live and the tribe is ready to go with it. And as they are leasing, copies of the leases and the lease documents, except for permits and residential subleases, do go to the BIA for encoding into the TAM system, which I did not have the acronym spelled out here, but it's the Trust Asset and Accounting Management System. It's the proprietary recording system that the BIA uses. Similar, I guess you'd call it like our county recorder, and then recording with the LTRO, the Land Title Records Office. So one might say, well, what happens to the trust responsibility of the United States now that they don't approve leases anymore? Well, they're not out of it. Certainly, they approved the ability to approve the changes to the ordinance, but they also have ongoing monitoring, enforcement, and compliance options as well. So they're still there, and if somebody is aggrieved, an aggrieved lessee, or the tribe wants to enforce the lease, the BIA is there to help them or eject them or whatever remedy may be needed. And in terms of if the tribe is not following their own ordinance, somebody has an ability to object to that as well. So the secretary still has a lot of authority over this property, of course. This is just a special carve out from 415 that allows certain things to happen. So here's what I relied on as sources for my talk today. And also I would point out these things there's an attachment somewhere. Jeremy probably has it on either on this webinar or it will be available on alta.org afterwards. Last thing I want to point out is the HEARTH Act regulations approved per tribe since 2012. I think the list is now at 51 tribes and more than that in terms of ordinances because some tribes have more than one. So a lot of those for samples are also available for review there. It's kind of an exciting area. And so with that, Orlando, I will kick it back to you and see what happens. Thanks.
Very good. Well, thank you very much, Sam, Sandy, Cindy, and Rolf. This was a very comprehensive, albeit quick, review of this area of the law. So we have a few minutes now to answer some of your questions, and we hope that we get a lot of questions coming in. And so with that, I will go ahead and remember, type your question into the question box, and we will try to answer as many as we can within the time left. One of the questions that we have received is from Kimberly, who asks about where are the LTRO offices located and how do you go about contacting them and getting the information from the LTROs, LTRO being Land Title Records Office. So anybody can take that question.
Orlando, this is Cindy. I'll take that question. There's, I believe there's 12 different separate land title record offices and 10 tribal land titles and record offices under the Department of Interior's Division of Land Titles oversight. I think you could go online, and I don't have a list in front of me of where exactly those LTROs are located. But again, typically the request for a title status report from an LTRO is going to have to go through the Indian landowner or the tribe. I think it will depend on each different LTRO may work differently in that regard. But typically the request needs to come from the tribe or the landowner. So you can try as a title company to request a TSR, but I think you probably will be working with your client to make that request. But again, I don't have a list of all 12 of those LTROs in front of me, that you should be able to find that online.
Great. Well, actually, I think that question relates to another issue that I think you discussed a bit in your presentation, Cindy, and you talked about certified TSRs. Now, there is also something called an uncertified TSR. Maybe you can tell us a little bit more about the distinction between those two types of reports that you can get from an LTRO.
Yes, great. Thank you, Orlando. Yeah, an uncertified TSR is what we refer to as an informational TSR. And it's exactly that. It's uncertified and it's unverified report of ownership and encumbrances shown by the Land Title Records Office. In many cases, the informational TSR is only current up to the last certified TSR. So if the last certified TSR in a particular parcel of land is 4 years old, then a new informational TSR will also be 4 years old, and you're going to have a gap between the date of the certified TSR and today. So in our title insurance world, we update or date down, however you refer to that process in your area, the last available dated policy to the current date, so our information is current, but it doesn't appear to be the case with an informational TSR. So to get a certified TSR, the Realty Office and the LTRO will have to go back and do a full new search rather than just going from the last one forward. They do an actual full new search. And so that's one reason why certified takes longer. But the key difference is the certified TSR, according to the BIA, is certified as true and accurate and is up to date. A report on the title status and ownership of land and encumbrances of land. So again, unlike the informational TSR, the certified TSR is supposed to be verified and accurate and is more current. Does that answer your question?
Yes, thank you very much. Well, at this point, it does not appear that we have received any further questions from our audience members, and we are at the 1 hour mark for our program. And so with that, I think we will go ahead and turn this back over to Jeremy for a few concluding matters. But again, please let me thank very much Sam, Cindy, and Rolf for their excellent work and for their excellent presentation today. So turning it back over to our coordinator.
Yeah, thank you, Orlando, and all the speakers. Great information on how to handle leases involving Native American lands. If you do have a question or you think of something later, please shoot us an email at communications@alta.org, and we will get it to the speakers. As Orlando mentioned, everyone is a part of ALTA's Native American Land Committee. Provide great information and collaboration on things affecting Native American land. Looking ahead, Cindy mentioned it a few times, the third and fourth parts of this webinar series will be put together and offered in the second quarter of 2021, and then the 4-part series will wrap up in the third quarter of next year with a case study and basically applying everything that has been offered in these presentations. And then you can also see the link to go to alta.org/webinars. This is where you'll be able to find the recordings of the previous of this webinar and the first one, and download all of the presentations and associated material. To wrap up, do need to recognize Old Republic once again for sponsoring our compliance webinars this year. And with that, that will bring us to the conclusion of today's presentation. Take care, everyone.
Thank you all for joining.